Welcome to the Unlocking Senior Resources podcast by Leave the Key. I'm Larry Wagner, and I've spent 30 years working with seniors, where I was a certified senior advisor, and the last 15 years in the home buying industry as a certified senior transition specialist, where I specialize in dealing with seniors going through a transition in their lives. This podcast is for seniors, those with seniors they love, and people who work in the senior community. In each episode, we bring on a guest who works to improve the lives of seniors. This podcast is your key to unlocking senior resources. Welcome. Today we're here with Peter Groffmann from Boyle & Groffmann and a law firm in Huntington. Welcome, Peter.
Good morning, Larry.
This is a podcast that focuses on senior issues, and you're an estates and trusts, or trust and estates, I think is the right way to put it, firm.
That's right.
But seems appropriate for our audience. So you're a young guy, you're an attorney. How did you become part of, so I think there's congratulations in the story, but how did you become part of this firm?
I actually started out as a paralegal during COVID, so there weren't too many opportunities, but it all worked out for me. I applied to the first job available, which in Suffolk, because that's where I grew up, born and raised here. Took the first job I could get. Started as a paralegal, eventually got sworn in. The bar was postponed 2 or 3 times for me, actually, during COVID.
Oh, because of COVID.
Because of COVID. Mm-hmm. Yeah, and I was getting married around the same time. So a lot was going on. I was getting married. I was going to get sworn in. I eventually become an attorney, and I stick with the firm, and we just kind of grow from there.
Right.
And then I ended up being put forward as partner in January.
In January?
So it's officially Boyle & Groffmann. It used to be Law Office of Patrick Boyle, and now we're partners.
So what time's going to be Groffmann and Boyle? That's what I want to.
At some point, right?
So anyway, I'll have a talk with Patrick. Now, anyway, so that's my congratulations. And by the way, we're recording this in August, so to put things in perspective. So it's just a part of this year.
That's right.
Right. So what we're doing now, we're working on a series with attorneys, and we gave you a whole lot of topics to talk about, all dealing with issues that address senior issues, because it's a senior podcast. So you're an attorney that does a lot of work for non-young people who typically don't do estate planning and so on. Typically, they have no estate to plan.
That's right, yeah.
And secondly, they're immortal. Ask them, they'll tell you.
Yes.
So they don't need that.
With one exception. I do have a friend who's going to have a baby, I believe in October, and I'm begging her to just create a guardianship provision.
Right.
Like, it doesn't have to be the perfect person, but just make your wishes known so that if something does happen, that's the only time I really recommend for younger people to make sure they have estate planning documents. If you have kids, just write something down so we know who's taking care of them if you and your spouse both were to pass in a common disaster.
100%. I'm embarrassed to say that my wife was like 8 months pregnant before we wrote our first will, and I knew better. We should have had that will written before we got pregnant. But because once you go into your first pregnancy, everything else is thrown out the window. But we got it done before my son was born. So, but yes, most people, the kid's 12 before they think of writing a will, and that's a problem. Or guardianship, as you said, the most important part.
And then at that point I go, well, all right, you're here now, no time lost, because you're with us,
you're still
and we're
here.
having this consult.
Right. So that's very, very true. As long as you're able to have discussion, no harm, no foul. But you never know. You never know. But with that said, you said you want to cover the subject of probate, and also we talked about another little subset of probate, not a subset, but another topic is disinheriting children. And coming from my background as a financial advisor, I have plenty of stories, unfortunately, doing probate, but also disinheriting children and unequal estates for children and things of that nature. And my philosophy, I'm curious to hear your philosophy. You're the same generation as my children. So I'm curious how the generations have impacted our opinions. So
yeah.
And so let's see. So where do you have to go? Where do you want to take this conversation? Where do you want to start this conversation?
So I guess, because as I was kind of preparing for this, I kept finding myself talking in technical jargon and in ways that I couldn't really express it to a layperson. So I think I need to start even further back than where I wanted to. I wanted to start with what is probate. And then I thought, well, let's start with what is a will?
By the way, this podcast is 7 hours long, so bring your lunch with you. Moni, I'm only kidding. I'm only kidding. Go ahead.
Okay. So I'll keep it really brief, but a will is basically a document that governs your estate and where you nominate an executor. That's all that it is. Yep. Now, probate is the process of proving that that will is valid. Yep. So, meaning, is that will truly the testator's wishes? Is that really what you wanted to happen? And then the executor is the person that is named to distribute those assets. Right. If you are going to have a will, you need to make sure that you meet all the formalities. That's what probate is looking at. Probate is really making sure that you have the two witnesses. Did you have the self-proving affidavit with the notary? Were you under any undue influence? Did you have lack of capacity? Is this a forgery? Right. Is this something that is fraudulent? All those things are examined in probate.
Not is it fair? Is it logical? Yeah. That's nothing to do with probate. Probate's strictly a legal question, affirming the validity of the will.
That's right.
Not the intelligence behind the will, but the validity of the will.
That's right. Is it valid? Right. And then the second part to that, once you establish validity, is who has authority? Right. That's the question for the executor. So when I say it opens up your estate being the assets that you own at death, we're also talking about who's the executor. So they're nominated in the will. Many people don't know that. The executor is nominated in the will, but they are appointed officially by the probate court, by the surrogate's court. Once they're appointed, then they can marshal your assets and distribute them. No, they can't change the terms of the will. They can't change any of the distributions that you make. It's just about giving them legal authority.
I want to make one comment about that. I remember I asked this question of my father. Again, we worked together for 30 years in the related field, and he always say to me, what the will says is what you're supposed to do as the executor. But no one's checking if none of the beneficiaries complain what you do. So if the will says your mother wants to leave money to her sister and her sister is demented and on Medicaid, you don't have to sit there. If you don't and no one complains, nothing happens. The government's not checking to make sure you distribute the money according to the will. Sometimes you use common sense, which technically is a violation of the will, but if no one complains, no one complains. I'm not giving you legal. This is not a legal statement. This is a practical statement. I'm not a lawyer. I can say whatever I want.
That's right. Yeah,
but,
that's absolutely right.
But I've had many of my clients do that where it just made no sense whatsoever.
Yeah, and you can agree to the distributions to some extent. Some people will come in and they want to make sure that their executor is not only someone that they can trust, but somebody who will follow their wishes. And I always point to them and say, well, you have to understand that what you want will be enforced. It is enforceable. You're not appointing somebody to do what they think is the most fair, to act in the most neutral way possible. You're appointing somebody really just to carry out your wishes. And if they don't, there are safeguards in place. I mean, this is why we go through probate.
Safeguards, but again, only if someone,
of course,
enacts those safeguards.
That's right. Right. That's right. If you all agree to it, then there's really no harm. I mean, you should honor their wishes at the same time. If it's to their detriment that you honor their wishes, like in a Medicaid scenario where this person will actually lose their benefits, or if they're a special needs individual, and, they're going to lose their disability benefits for receiving their inheritance. I think it's more consistent with the testator's wishes to perhaps avoid that.
Well, that's exactly. We didn't change. I did my own mother's will. We did some modification. I know she around. This is what she would want, but she had incapacity for 3 years prior. But if she could have rewritten her will, she would have rewritten her will in those 3 years because life changed. Her beneficiaries' lives changed during those 3 years. So we did what she would have wanted done. So that's important as well.
So we talked about what a will is. We talked about what probate is, which is really proving the validity and then also appointing somebody with authority. Now, probate, I mean, from my perspective, it sounds like a good thing. It sounds like the most ideal way to make sure that the will is enforced. Now, why then are there so many articles? Why is there such a large body of work dedicated to avoiding probate? I mean, I would say maybe 80% of my job is really about probate avoidance when you think about it and you sit down with an estate planner. Absent the litigation aspect. The reason why you probably want to avoid probate is because the court costs are excessive, the time frames are very, very long, and then also the procedural complexities and nuances really require an attorney's intervention. And you never can quite tell whether or not it's slack on the part of the attorney or whether or not it's a built-in wait time to the system. For example, I'll get calls, a year and a half into a probate, and they'll say, what's going on? And the honest answer is the court hasn't looked at it. In Kings County in specific, we're looking at wait times from 2 years from filing. I have a basic estate, 3 children, and we're still waiting on that. They appointed a second judge just to make sure that we aren't falling behind too far.
You hit a nerve. We went to contract on a house 3 years and 3 months ago in Kings County, alias Brooklyn. And the gentleman owns 80% of the house. His deceased mother owns 20%. His mother owns 20%. And she died 10 years prior to 3 years ago. But he never bothered to do anything because his brother was living in the house. His brother died, and he wants to sell the house. And it's been a nightmare. 3 years. It's maybe 3 years and 4 months by now. And the case is now on the desk of whomever, because they've now been asking questions.
And
so
I bet
it'll still take a few more months probably. And there may be some people contesting. It's a million kids and grandkids and nieces and nephews.
And I would bet it's just a will or no will. Is that what's
there
going
was
on?
Actually, Mom had a will. And 3 kids. My client's 82. To put things in perspective. 3 kids, 2 died, and went at a hobby of impregnating women all around the city. But never marrying their mothers.
That's
Never
quite a
marrying the
hobby.
women. But it was a good hobby.
Yes,
It's a good hobby.
yeah.
Right. So there's all these nieces and nephews that are unknown. So we paid for a genealogy study, and my client's sitting waiting to get what's a 7-figure amount of money
Yes.
for over 3 years, which is life-altering for a man in his 80s, and the court doesn't care, and he can't afford the house because he wasn't paying for it. His brother was paying for it. He doesn't have the money to support this house. So we've been paying for it. You mentioned something, it's surprised we did something else we talked about pre-air, but we've been shelling out the money to support the house, utilities, paying for locksmiths, we've shelled out, I don't know, about $25,000 at this point, which he just doesn't have.
Tremendous.
Yeah, and we're paying the legal costs now for an eviction.
Now,
Because the
Kings
squatter
is
moved in.
probably the worst you can get.
It's the worst you can get. How long's Nassau, Suffolk County take by comparison?
So Nassau isn't too bad. I would say 6 to 8 months. Now,
see, that's not too bad. That's a crazy comment.
Isn't that? Yeah.
Okay.
I know. It's just because I'm used to getting the phone calls over the course of 2-3 years.
Right.
So when I get something in Nassau, I'm like, don't worry.
Right.
6 months will be over.
Right.
We're going to get letters.
Right.
Letters testamentary or what appoint your executor.
Right.
Once your executor is appointed, you could sell that house and you can move on. So not too bad. Suffolk has actually fallen a little bit further behind.
Really?
It wasn't always like that. But now Suffolk is a little slower than Nassau. And we also have a new surrogate coming into Nassau, which is going to be interesting. Hopefully they can keep up the pace. Messina, I believe, in Suffolk was appointed maybe 2 or 3 years ago now. And he's been great. But the court times are what they are. They're about, I would say, maybe 8-9 months. I have basic estates with 2 heirs.
Crazy.
And they're waiting 8-9 months.
8-9 months. So I have a question, and I've always wondered this. There's 2 things you're waiting for. One is you're in queue, and the second one is you now call to the front of the line. How long of the 8 to 9 months is the queue versus once you're at the front of the line and they're working on you?
I would think that the queue is probably 6 months, and that's just based on doing a number of them this year.
It's
about 6 months, and then you get something back from NICEF. NICEF is the e-filing site where all the attorneys are going to be filing their paperwork. It's now mandatory post-COVID. We have returned to in-person, so we will be appearing in Riverhead on these matters. And Nassau has not, which might account for some of the efficiency.
Right.
Something to consider. Queens is also returned back to in-person, but to answer your question, the wait is approximately 6 months, and then you're going to get a notice from NICEF saying, okay, your paperwork has been filed, and you'll get a little AP. You think it means approved? I don't know what it truly means because it doesn't mean that I'm getting letters anytime soon. And then they'll get back to you with maybe a court sheet or a request for amendments. It could be anything as clerical as a comma in my experience.
Really?
Yes. And if it is in the wherefore clause, now we're getting a little technical, but there is a section of the petition where you ask for relief. It's called your wherefore clause. If your wherefore clause needs editing, not only are you going to have to amend, put yourself back in the queue and wait, you're going to actually have to go back to the client, have them re-execute, re-notarize, and send in the petition again. Not ideal. I can usually make the amendments on my own, but not if they're in the wherefore. My point is not to really relay the content, if you to rely on the content. My point is really just how complex it is, how similar it looks to a DMV transaction. Like, does anybody transfer their title the first time?
Right. How similar looks to a DMV.
It's needlessly clerical.
Right.
And there's only one court for the whole county.
Right.
So something to consider. Everybody who passes in Suffolk, we're going out to Riverhead.
Right.
And then
just
everybody
out
who
there
passes in Nassau, we're going out to Mineola.
Suffolk is gigantic relative to Nassau.
That's
Same
right.
population, but just geographically.
Yeah.
It's a long distance to go to Riverhead, depending on where you are. We're in Huntington, the west end of Huntington, so Riverhead's far. I spent an hour driving out there the other day. I had to go to court for something. Yeah.
It's about an hour.
Yeah.
It's about an hour. You wait for the judge. You have your citation issued.
Right.
That's maybe one other thing to talk about. Sometimes the wait times are really just the queue. Another times you're waiting for the queue to give you what's called a citation. If your heirs don't comply, well, then you need a citation issued by the court. A citation, the way I usually describe it in layman's terms, is an invitation to court because you have a right as a beneficiary to know that a will exists. If everybody doesn't consent to the will being probated, whether they actually have legitimate issue or they just don't want to sign anything. I think I have more people who just don't want to sign anything than people who have legitimate objections.
So everybody who's named in the will has to agree to it, or they have to disagree if they want to be heard? Like, is it assumed agreement?
No, it's not. I wish it was assumed agreement. What it is we have what's called distributees in New York. Distributees are your heirs at law, meaning these are the people who would take but for the will, meaning if the will didn't exist, these are the people who would inherit. Those people need to receive service of process through citation. Citation is an invitation to the court. It means, come down, we have a court date for you. If you want to be heard, this is the time to be heard. Once that date lapses, we can have an executor appointed. But my point isn't really to explain all of the technical issues. It's just to show you that there's a lot going on here. It's not just bring the will to the court and have them stamp it. It's, let's file for citation. Let's wait 6 months. After citation is issued, there's going to be a court date. If nobody appears, that's as smooth as it goes. If somebody does appear, and we'll talk about that. We're going to talk about that with disinheriting heirs. These people have the right to appear. If they don't, you're okay. But if they do, we're looking at the possibility of objections. We're looking at certainly a pretrial conference or two, and we're likely looking at depositions at the expense of the estate. But that's more than you asked for.
There you go. I'm not going to ask another question. You continue. Well, at least not for a few seconds.
Okay. So when I talk about probate and the process of proving the will, making sure that the estate is open, making sure that all of your assets are marshaled, that the executor is appointed, this process is never timely. It's never easy. It's always, I should say not always. Attorneys probably should never say always. It's typically going to be 6 months to a year, whatever county you pass in. Now, some attorneys, I've listened to a number of attorney-based podcasts, and guys much older than myself will tell you that not all probates are bad probates. If you have a few heirs, if you have a few items, what's the difference? Go through the probate court. I'm not a trust salesman, which is kind of what you get accused of being if you're very anti-probate, but I haven't seen a good probate. I don't know if it's just post-COVID, which is almost solely where my practice lives and where my experience is, but post-COVID, we're waiting 6 months to a year on very basic things where, I know the law inside and out on these issues, and the clerk on the other side is going to tell me, well, we actually have a court rule that speaks to that. And
right.
Sometimes they do, sometimes they don't. The attorneys call that clerk law. It's like when the DMV, when the DMV teller tells you, well, actually, you're going to need a bill of sale on that. It's like, well, it's actually a gift from my grandparent. It's like,
right.
Regardless, we're going to need a bill of sale because I have a checklist, and that box is unchecked. So you go back. Okay, well, my grandfather has passed. He can't sign a bill of sale. I'm going to have to speak to a manager. It's like, I just know. There's no sense to it. It's just
yeah,
checking boxes.
Yeah, absolutely. For years I was antitrust for the wrong people, but going through probate with my parents, it's a relatively arduous process.
So you're a convert.
For the most part, I was pro trust I have trust, but I see why people want to do it, but there are people who don't have a home to sell.
That's a good point.
They have 2 kids who are going to inherit everything, and the 2 kids are well-heeled, and the money's sitting in a brokerage account in a bank account. I put a TOD on a transfer on death or a beneficiary designations and call it a day. Sometimes you can keep things as simple as possible. The simpler your assets, the simpler the planning should be. That seems like a very basic comment.
You don't. That's why I say I'm not a trust salesman. I'm not. Right. I'm not enormously into trusts. I don't advocate for trusts over other non-probate vehicles.
Right.
I am anti-probate.
Right.
But I'm not pro-trust.
That's a great distinction. One attorney who he knew very well from the firm we used to be with said he just came from a seminar that was trusts are a cash cow. That was the title of the seminar.
And for who?
Right. For who? And it wasn't for the client. Yeah. It was for the attorney and how to sell trusts. Attorneys aren't supposed to be salesmen. They're supposed to be advisors. And when you're selling a product that generates money, he said, so I can charge, matter of fact, I know someone, they spend $15,000 writing up trusts. And the amount of money is going to save them in the end, let's call it even $15,000, but 25 years later. So it just doesn't make any sense. And they have people who fit into the category I mentioned who had no assets of any consequence. So there was no point. It was strict. That guy must have taken the same seminar. So
general rule of thumb, if you don't have a house, you probably don't need a trust.
That's really simple. But on Long Island, most people own homes.
That's the thing, though. Yeah, I would say 90% of my clients, if you're coming in and doing estate planning, you probably have a home. Yeah. You probably have children.
Yes.
But if you don't, you're probably also not looking into estate planning too much either.
You're right.
So I don't get too many of those.
People without children think they don't need estate planning. But that's crazy.
Fascinating, yeah.
It's fascinating. I'll just say crazy. You're being much more polite than I am. Go ahead. So, but
yeah. I mean, if you don't have children, you still have to wonder where it goes.
Right.
I mean, ultimately, there's a statute called the intestacy statute. If you prepare no estate planning documents, New York has a default for you.
Right.
It's going to go somewhere.
Yeah.
It's just probably going to go somewhere you don't like.
That's right.
Fascinating. So the estate statute is located at EPTL 4-1.1. I can't do that with all of them, but that one's off the cuff.
There you go.
That one is everybody knows that one. I'm just showing off. But the intestacy statute reads the first $50,000 to spouse.
Yep.
One half to spouse, and then the other half to children.
Right.
Almost nobody wants that.
Right.
I've noticed that if you have spouse and children, you usually want everything to spouse.
Yes.
Or if you don't, then you usually want less than half to go to spouse.
Right.
But nobody wants the first $50,000 and half to spouse.
Right.
I've never had anybody even come up with that out of their imagination and go, you know what I really want? I want to put this random numerical value to what I'm going to give spouse first off the top, just off the top.
Right.
And then I want one half of the remaining balance and then the other half to children.
Right.
Spouse is either a vessel for the children.
Right.
Or you're going to try and disinherit them through other means, or you're going to have separate means by which you provide. Some people have separate bank accounts. It's a lot like that.
Yeah.
But I've never had anybody actually want the default. And New York has a few statutes like that estate planners actively remove through the execution of documents. Fascinating. But back to your question, with people who have no beneficiaries, where does it go? Well, it goes under the estate law, the intestacy law.
Right.
If you have a spouse, one half to spouse, $50,000 to spouse, one half to children. If you don't, well, then everything to children.
Right.
Not everybody wants that.
No children goes to your parents.
No children, it's going to go back up to your parents. No parents, it's going to go back down to the children of parents who are your siblings. Then it's going to go back up. It's going to go to grandparents. If no grandparents, it's going to go down to aunts and uncles. And then the aunts and uncles goes all the way down to first cousins once removed.
I never heard aunts. I always heard cousins. I've heard aunts and uncles. So your cousin who came with torn jeans to your wedding may inherit your money.
Yeah, because the way that it reads, it always goes from testator and spouse to children. Then back up to parents to children of parents. Okay. And then it'll go back up to grandparents, to children of grandparents who are really
your aunts and uncles. Yeah. I never heard it put that way. Interesting.
Yeah, you know why? Because I've looked for the simple language that shows you all the relationships.
Yes.
It's just not in the statute. The statute shows it clearly going down the bloodline that way in more complicated language than I feel like any layperson can really access.
Right. I was close. I never heard aunts and uncles. That makes sense what you're saying. Yeah. Interesting. But this is God. I really wish this was a 7-hour podcast because I have a million things to talk about. But you go ahead.
Oh, okay. Well, when it comes to probate, I think we really touched on what that is, and I'll just summarize. I like to do that in my consults. I don't know. I feel like it's more edifying to kind of digest things in small pieces. So I'll tell you what you got, and then if I didn't do that, I'll touch on it. So you know what a will is. A will is basically setting forth your wishes as to your estate. It is appointing your executor. We know what probate is. Probate is proving the validity of that will, and then appointing somebody with authority, the executor, to distribute those things. We talked about why you want to avoid probate. You really want to avoid probate because of the long wait times and costs. From my perspective, post-COVID, there's no such thing as a good probate. And you also have to consider, where are your assets going in probate? Are they going according to the will? Or if you don't have any documents, are they going according to the intestacy statute? The next thing I think we probably want to touch on would be disinheriting children. That's one of the topics for today. We know what probate is now, so we have a good foundation.
Hi, I'm Larry. And I'm Ben. We're the father and son team of Leave the Key Homebuyers, and we want to buy your house.
We specialize in working with seniors who are transitioning out of their homes, and we understand what you are going through.
So if you're considering selling your home and would like an alternative to the traditional overwhelming process, reach out and see how we can help.
Do you have an outdated home?
No need to update anything.
Have a home that needs repairs?
Don't bother with repairs.
Don't want to take everything with you?
Leave whatever you want behind.
Dreading the headaches that come with agents?
Sell your home without paying a commission.
Dreading prying neighbors, attending open houses and passing judgment on your home?
No need for public showings.
When you sell to us, you'll have all the certainty of closing on your timeline, not someone else's, and there's absolutely no pressure.
Visit leavethekey.com or call us today for a no-obligation offer at 631-388-7771 if you want to sell your home today.
Before you do that, I have a question. I'm prefacing my question by saying I don't know if it's answerable, but it's askable. So I will ask it. And if someone's in the saying, again, this is really geared towards older people, and when I tell people, older people, I'm 67, I'm a senior, so I'll rephrase that. This is geared towards senior citizens, or I say, or children of senior citizens who learn to help take care of mom and dad, all right? So, but it's all about the senior market. So most people in the senior market have already written the will. But this goes to those who haven't and the kids who are listening for the benefit of their parents. And that is there a price range for a will, or how is a will priced? I've heard so many ways how people pay to go through, how they pay attorneys to go through probate, which is going to be my next question, or how much people pay for a will. Just for the record, my will, and I have multiple trusts. My will and trusts, with my wife and me, are about upwards of 200 pages because we have 7 businesses, tons of real estate, multiple complications, special needs granddaughter. We have like everything thrown into one mix. A will's probably, for those who aren't watching, I'm showing maybe 1.5 inches thick. And just everything's double, this is my wife and I. And that's not typical. So I spent a fortune preparing mine, but I wouldn't count that. So what is a typical person who has their IRA, which technically doesn't go in the will, but most people have an IRA or the pension plan. They have a couple bank accounts. Maybe they have a brokerage account. They have a house, a car. And that's America.
Yeah, probably like a $1 million estate on Long Island,
right.
kind of like
there you go. Right.
Just $1 million. So if we're looking at an estate like that, a very simple, basic, kind of cookie cutter, bread and butter estate, I would say the cost of a will, as opposed to going through a probate, is always going to be minimal as long as you find the right person.
Right.
Attorneys used to draft wills for hundreds of dollars in
right.
hopes that they would get the probate work.
Right.
Now we kind of draft trusts, which put it back in the family's hands and remove the will from the court proceeding and remove them from the attorneys. An average probate, I'll say, is going to be probably $5,000 to $10,000. I think that's just kind of industry standard for our practice area.
Okay.
The first $5,000 being prepare the petition, get the executor appointed. The next $5,000 being maybe go through an informal accounting proceeding. Marshal all the assets, distribute them, prepare little receipts and releases as to the accounting paperwork. Probably $5,000 to $10,000. A will should not cost anywhere near that. I would say a will has to, the highest it could possibly be for a will. I mean, I'm going to date myself if anybody sees these videos later on.
It's 2025.
It's 2025. Adjusted for inflation, I think it would be. I think the highest you could possibly go for a will would probably be $2,500, the absolute highest, and then anything in between there is fair game, including the $15 form at Staples.
Right.
Not that I advocate for it, but I think that's the highest you could go.
Right.
I usually don't touch that.
Right. Okay.
But I also want to make sure that seniors out there aren't getting scammed and they know what a reasonable price is.
That's why I asked.
I couldn't see you going any higher than that.
Right.
Knowing what the probate cost is, and should I just go through probate? And One thing to also consider too is the will sends you to probate. I mean,
absolutely, the trust is what is the probate avoidance tool.
People don't know that.
Right.
I get many questions like, well, even if I have a will, right? I mean, my executor is in my will. No, your executor is nominated in your will. Your executor is appointed by the court.
Right.
Probate means proving the will, proving that it's valid, appointing your executor. So the expense involved there is going to be the will plus the probate.
Right.
The trust is kind of where we should probably make our comparison.
That was my next question.
Is a trust? Oh, okay.
Oh, there you go.
So I foresaw it then.
There you go.
So the
it's
trust
a clear
usually,
line of thinking that like an attorney would have. Yes.
Yeah, I usually try, because I know my father, he probably would never see an attorney in his life. He's just one of those guys. He's not going to go to the doctor. He's not going to see an attorney.
Right.
And I'm the same way. I'm not going to do either of those things. I just happen to be an attorney.
Right.
So
I'm not talking to any other ones.
Yeah, and I don't advocate for that lifestyle. It's just like kind of the way we grew up in Suffolk County and around Ronkonkoma like that. I don't remember a time where we saw an attorney like that. So I always try and weigh the cost benefits, being a lot of my family members will probably end up going through probate and they won't have a trust prepared.
Right.
The cost of a trust is usually going to be around $5,000.
Okay.
Whereas the cost of probate is going to be $5,000 to $10,000.
Plus the will.
Yeah, that's right. You also have to consider
the convenience.
The convenience of a trust.
Right.
You also have to consider the aspect of if you do own a home, which is most likely the reason why you have a trust.
Yep.
In a scenario like yours where it's sitting unoccupied for 3 years, accruing
not
taxes.
unoccupied now, they're now a squatter.
Oh,
it's one of those offspring. It's actually one of the children of the offspring.
Yeah, so like $5,000 for a trust versus, peace of mind to not have a squatter in your home, to not be paying taxes on your home this entire time. When I say you, I really mean your beneficiaries.
Right.
That the house is now dilapidating, cannot be sold.
Correct.
I mean, we've had things where pipes burst in homes in the winter.
Oh.
I mean, it gets cold up here. We're not.
I bought those. Same exact scenario. Same thing. Couldn't sell it. The pipes. I live in Florida. Mom and Dad live in Suffolk County. I didn't winterize the house. I don't know if I'm winterizing house. I live in Florida. Oh, yeah. Right? And they're gone. And winter came. 2 winters came, whatever it is. They died in December. We haven't gotten a paper together. It's now the next January, and the pipes burst. And nobody knew till the neighbor called. The water's pouring out the basement windows. And
I'll tell you a funny story
you want to buy
about
the house?
That. So while we were in a probate proceeding with a questionable will, so this proceeding's going on for a long time now. We head into winter, and I get a call from one of the beneficiaries' girlfriends. And it's usually like that. It's usually not somebody who's actually related. It's usually somebody with no vested interest whatsoever who has the largest issue. Right. And if they can whisper in the ear of somebody who does have a vested right, that's where we have a problem. Anyway, I get a call from her. I tell her, I really don't represent you. Right. And she said, well, you represent the estate, so you do represent me. I said, well, no, I really represent...
You're not even in the will.
You're not even in the will. I represent the executor.
Right.
And to the extent the estate is, under my jurisdiction, I really don't have the same liability as somebody who would represent her or represent the estate. So I was nice to her about it. But she told me in a very angry manner that a pipe burst in the home and that she was going to come after our malpractice policy. I said, that's really not how this works.
Right.
I mean, respectfully, like, let me just run this hypo with you. I'm an estate planner. I have a number of estates. You know, I'm
Right.
also a litigation attorney, so I'm aware of this. I have a number of homes and probates that are open over years. Could you imagine a scenario where I'm responsible for every pipe in every house that I do this for? I mean, I have people who pass with multiple homes,
Right.
pipes, you know.
Right,
Like,
right.
this is not something that I'm going to be responsible for. So it is fascinating, like the extent that people think that you're liable and what can also go on in an estate that's completely outside of your control that you're not going to really see recovery
Right.
for. So when you weigh the cost benefits of a trust versus going through a probate, there are innumerable consequences to not having a trust if you have real estate, just based on time. So more time, the more events that could occur within that time.
Correct.
So anything that you have experienced, that can happen
Right.
when you pass.
I'm just real quickly, and then we'll get to the next topic. There's this one gentleman. The house is over $1 million. If he had inherited that $1 million 3 years ago, not even the 3.4 in 3 years, 4 months, just 3 years ago, just the earnings on $1 million, assume he would have gotten 3% interest, right? That 3% on $1 million times 3 years is basically called 10%. On $1 million, that's $100,000 of expense. And the house is devaluing. I'm hoping that when I go to get it, I'm still willing to pay the same price. There's been a squatter in it for the last 2 years. Lord knows what the squatter's done to the house. And there's a leak in the house, which is causing a $5,000 water bill and damage. And the squatter won't let anybody in to take care of it.
You know what's interesting, too, is
the house may devalue as well.
sometimes you have issues with children squatting in the home. So one of the children says, you need to leave. Another child, and it's always one if you have three.
Yes, it's always one.
That's a general rule of thumb.
Yeah.
And so...
and the second child either sides with the one at home or also wants to sell it.
Exactly.
Yeah. This is like a good segue, actually, to disinheriting. But you did that on purpose. You're really good at this. Yeah.
My first time.
There you go.
Beginner's luck.
Beginner's luck. Go ahead.
So if we're going to talk about disinheriting children, first we should probably define what disinheritance is and just do the lawyer thing where you set your terms out. Disinheritance is really the removal of a distributee. Now, what is a distributee? It's a unique term in New York law. I remember coming out of law school. I did not understand what that meant. I did not learn the word distributee. I learned all sorts of different fun little Latin phrases. What's a legatee and what's a settler? But I never heard distributee before.
Settler, the guys from the Mayflower.
The Pilgrims. So the distributee is an heir at law for New York. They are the people under the intestacy statute.
I never heard the term, but I assume that's what it meant. But I never heard the term.
Yeah, so heir at law would be synonymous in New York with distributee. And they're the person who has a vested interest but for the will.
Now, would that be beyond the children and the spouse?
It can be. It can be.
Assume there are children and a spouse.
If there's children and spouse, it ends there.
Okay.
So that's the way the intestacy statute works in terms of distributees and who has a vested right. First, it will be spouse with no children. Then if spouse and children, it'll be the 50,000 to spouse, one half to spouse, the other half to children. Then after that, we went through our
then
long
it's children,
list.
then it's parents.
And sometimes we get down there. I have estates where I'm down to first cousins once removed, and it's
really
absolutely. I'm chasing them right now through Estonia. I mean, it's unbelievable.
Oh, my
all
son's
through
in
Eastern
Estonia.
I mean, I actually have one where they're exclusively located in the Ukraine right now. And so, talk about the unforeseeable probate circumstance. I am trying to contact first cousins all throughout the Ukraine right now, which is an active war zone.
Yes.
And the court says, well, if you can't serve them. Now, mind you, we're down to first cousins. And when we're at first cousins, there's a lot of them.
Right.
Because in the family tree, the lower we go, the more people. Because aunts and uncles have had
every
children.
Family tree, it starts with two people and it goes like this.
And then first cousins, it's like, speaking of, Gerard Way is related to Joe Rogan. I mean, those are first cousins. It's unbelievable how far your family tree can spread out. So I'm trying to find these guys through an active war zone. And I reach out to the court. I say, there's just no way. Like, you turned on the news before, right? And the court says, you're going to have to publish in a Ukrainian newspaper. I'm like, is that really much better? Like, are they really going to see that? Is that really giving them their due process? So now I argue with them for a little bit. You generally have to appease the court, but I think this resonated.
Right.
Nobody likes what's going on
Right.
in Ukraine, and they said they're going to dispense with that, but I still need to prepare the order for the judge to sign to dispense with it. So
Right.
I'm going to work on that a little later.
Huh.
But yeah, distributees can go all the way down to first cousins, meaning that those are the people who need to be served with process.
Right. Assume there's no one alive ahead of them.
That's right.
Right.
If there's no one
Correct.
alive ahead of them, so no
Right.
spouse, no children, we
Right.
just
Yes.
keep going
Right.
down the line.
And after that, where does it go to the state?
After that,
I never asked that question.
after that, it should go to unclaimed funds. And
Right.
I had things, I've gotten things out of unclaimed funds before, usually surplus monies, like for homes that have been foreclosed on because
Right.
taxes have accrued
Right.
and nobody's paid them, whether during life or thereafter. And it's the process is called a sheeting. It sheets to the state. At that point, the state is the only person who owns. But back to disinheriting children, because this is
Right.
all going to actually apply.
Right.
Again, you never have to understand the procedural aspect of this. You just need to understand the concepts that you have relatives, and these relatives have vested rights, whether they're in the will or not. The only way to avoid contacting these people is going to be to have a trust to avoid the probate proceeding altogether. Disinheriting children is about removing a distributee. A distributee is an heir at law, which are all of the people in that long, long list, including spouse, children, all the way down to first cousins once removed. If you disinherit somebody, just understand that you don't do so in a vacuum. You know why you chose to disinherit them? You have your own personal reasons. You can do that. I have many, many documents that disinherit children. But you have to do it the right way, and you have to realize that what you've done will come to light. You don't have this done in the dark. Your distributees, so we're coming back to that word. Your distributees will receive notice. They will receive a citation. The citation, again, is that invitation to court. So even if you have a will,
Right.
and let's say you name those two children that you love,
Right.
and the black sheep of the family, you
Right.
say, you're getting nothing, or you're getting
Right.
$1 or something like that. Well, just know the will's going to go to probate. The judge is going to issue a citation for all distributees to appear. The two children who are getting everything are going to be very happy to sign that. Yeah,
Right.
they're going to be
Yeah.
more than willing to sign
Yep.
a waiver and consent saying, we consent to the appointment of executor who
Yeah.
is probably them.
Right.
In all honesty, it's probably them. So, of course, they consent to themselves.
Right.
Whereas that third child
Right.
or that third distributee, whatever the relationship is, they are likely going to appear in court. If they do live in the state,
Right.
they're going to have to be served with the paperwork in order to appear. They're going to be served with a copy of the will. So everything that you did, they're going to know about it. And then when they do appear, they have the opportunity to file objections.
Yep.
Now, they might say, I want more time. They might say, let's do a preliminary conference. The judge would usually do that, set it up for a preliminary conference.
Which is down the road.
Yeah, down the road. So now we're kicking the can.
Yeah.
We're going to wait another 2 or 3 months.
Yep.
We're going to have that conference. Sometimes they let you do it virtually. Sometimes they don't. I know I was in Queens, and now I'm driving out to Queens pretty regularly. Because one of the children in this hypothetical, I mean, it's based on a real scenario that I'm dealing with in Queens right now. One of the children is thinking about contesting. And so what we're going to do is we're going to talk about it for months. And when we don't come to an answer immediately, which we rarely do in the law,
Right.
we're going to have another one in another month or so. And we're going to have another one. And if we think that it's profitable, we think that we're getting somewhere, maybe it'll get settled, but maybe it won't. I mean, there was a reason likely that this person was written
Right.
out. Was it the parents' idea?
Right.
Was it the two beneficiaries' idea? I'm
Right.
always a little suspicious of that when I see
Right.
two people getting everything to the disadvantage of one.
Right.
Who took mom to the estate planner? Who took dad to the estate planner? Who executed these documents? Does that really look like mom's signature? Who was taking care of mom?
Right.
There's a presumption against caretakers in New York State. So if you're really the person in the home, I should say the court, to avoid pronouns, the court, for clarity, is suspect of persons who are going to receive, who are caretakers.
Right.
So disinherited children, just realize you have to do it the right way. You have to see an estate planner if you're going to disinherit a child. And know that what you've done will come to light. They will receive a will. They will receive an invitation to court. If you do want those children to actually inherit who you've named, and you don't want the disinherited child to come forth and to prolong the whole proceeding and try and extort a settlement, make sure you have a trust. Make sure you have something that avoids the proceeding. The proceeding is what's vesting them with rights as distributee.
Yep.
Something to consider.
It's very difficult. So question, when you disinherit a child in a will, do you write why you disinherited that child in a will? Do you write a separate letter, or you do nothing? Just give the kid a buck and say, I don't want anything to go to this child.
There are different strategies when it comes to that. If you're going to write into a will why a child's disinherited,
Right.
make sure it's nothing inflammatory.
Right.
Like, not because, I've had people write some really terrible things.
I don't like my daughter-in-law.
Yeah, because you married so-and-so, and now you've destroyed the family. I'm passing, I'm leaving you this $1 because that's the most that you've ever done for me during my life. Like, things like
Right.
that. It's like,
Don't do that.
no, because what's going to happen is, and not even from a personal, you shouldn't do it in general.
Right.
You shouldn't leave somebody with that kind of feeling. I think that you'll likely regret
Right.
it at some point. It's going to be
Right.
too late to change it.
Mm-hmm.
But also legally, you're incentivizing litigation. Is your disinherited beneficiary going to appear in court if you say that they receive nothing? Maybe. There's a chance. I think more likely than not, if they have two siblings who are getting everything and it's a will executed late in life, especially if there's a caretaker child involved, I think that other child, regardless of their relationship and how sour it is, I think that they will likely appear in court and contest. Now, if you write something in the will,
there was influence on this caretaker child.
Yeah.
Right.
Yeah. There's always, even if there's not, there's always the suspicion.
Right.
And so they have this opportunity to come forward.
Right.
And they will likely avail themselves of that. I would say more likely than not. I've had more people show up than not. However, if you write something into the will, something inflammatory, that particularly something that sounds like it came from one of the children.
Right. That's interesting.
Yeah. It's like, I know that voice. That's
Yes.
my sister's voice talking through my mom's mouth.
Right,
And
right.
that they will most certainly appear then.
But so appearing is one thing.
Yeah.
It's a hassle. It's a delay. It costs money. But what grounds, I know an answer, does this disinherited child or beneficiary or potential beneficiary have to argue it? They can.
Yeah.
Mom had undue influence. She wasn't of sound mind when she rewrote her will. Things like that. But
You have 4 grounds.
Right.
You have 4 grounds. So you have lack of capacity. The person did
Right.
not have the capacity to execute. They didn't have legal capacity.
Right.
Very unlikely.
Right.
Very low capacity.
they're going
to
to bring
execute a will.
you in as the person who drafted the will, say, yeah, she was perfectly fine when she signed that will.
Yeah.
And then that argument, does that argument then go out the window? Or they can still continue to fight it? Because Mom loved me, but the attorney says she was fine.
Generally.
Okay.
All of this would be aired at
Okay.
depositions,
Right.
if not settled beforehand.
Right.
But it doesn't always, and there's a reason why. There's a real incentive for them to bring it all the way to depositions, and we'll
Right.
talk about that. But for now, it would be lack of capacity. They didn't have the capacity to execute the legal documents. Undue influence.
Right.
The caretaker or the child
Right,
or
right.
the caretaker child decided to unduly influence the person and brought them to the estate planner, and you'd have to prove those things. And then you have fraud and you have forgery. Those are really your 4 traditional
Okay.
objections.
What would the fraud be in this case?
So it would be, they all somewhat overlap.
So I
but
see forgery and fraud I see together. I don't.
yeah, so fraud would be like you induced them
Okay.
to make this
Okay.
decision. You decided that this really would be the best for them.
Right.
And you essentially derived a benefit
Right.
through some sort of
Okay.
malfeasance, some sort of
Got it.
trickery. and then forgery, obviously.
Yeah, that's self-explanatory.
I've dealt with that. I mean, I was handed a forged will. I looked at it. It was clearly a single page document that was printed off of Microsoft Word, whether it was from Google or from their own imagination. I don't know.
Right.
I would imagine it probably was from Google because it had so many underscore spaces.
Oh.
And they disinherited their child through this document. So this actually leads into, if we are going to disinherit, how are you going to do that? How should you go about it? And that's why I say you should really see an estate planner at that point. Not everybody has to. But if you're going to disinherit a child, you have to make sure it's done the right way, and you have to know that they will likely contest. Like what you were saying as to providing a reason, this will had no reason. In fact, it was a disinheritance by omission. They just did not enter the sibling's name.
I hear they say that's harder to
It's
defend.
so difficult to defend. So what they're doing when they come to me with that is they're asking me to prove to the court that this is what their parents' wishes were. That if this document was valid, that they had capacity. It's like, there's arguments on all grounds for this. I mean, you have a document with underscores in it, completely empty fields.
Right.
You have children listed out. It says list your children in the document. I think the document, whether you were disinheriting your children or not, intended for you to list them. You should make mention of them so that we know that that you had these children.
Correct.
That it was an intentional omission.
Right.
I mean, I write documents that disinherit people all the time. I still write them down as family members.
Right.
I mean, it's one thing to be cold. It's another thing to just be inaccurate.
Right. Correct. I've heard people, let's say they're worth $10 million, they'll leave $50,000 to one child and, $9.5 million, whatever, I'm doing simple math to the others. And then say, if you fight it, you lose the 50 grand or the 100, whatever it is. They give incentive not to fight, and there's no grounds for you to win, and if you fight, you're going to lose this money.
That's right. So we talked about disinheritance.
Yeah.
How that's defined.
Right.
If you are going to disinherit, how you're going to do it is kind of where we're at now. Do you do it with an explanation? If you do so, you don't want to be inflammatory. And then we're talking about now how to disinherit. Well, what you've described is called a no contest clause or an interim clause to strike fear. You have to mention, of course, if you are going to use one of these clauses, you have to give them a certain amount, like $50,000, to make it worthwhile. So I'll explain how it works. The no contest clause says, in the event that you contest my wishes, you lose your inheritance under the will, meaning you're going to receive nothing. Now, if you give them nothing, or if you give them $1, the only thing that they are going to lose is that dollar or nothing. It's not enough incentive. You give them $50,000, like what Larry's saying. Well, now that's enough money for them to say, maybe I'll walk away. $50,000 sounds pretty good as opposed to receiving nothing.
I have no grounds for my argument other than I want a few $1 million, but chance I'm not going to get that, so why risk the 50?
Yeah, and people know, I think, when they do this, that, like we were talking about before with contests and people with vested rights, these distributees who can come forward, especially disinherited children. Just because they come forward doesn't mean they're going to win.
Right.
I think that most of the people who are disinherited who come forward, I don't think they even intend to win, at least from what I can grasp. Now, it's probably beyond my field to jump into their psychology, but I don't think that they intend to win. I think they truly intend to be an obstacle. They want to be obstructionists. They don't want the proceeding to move forward at all, and they think that they're generating more court costs.
Right.
And the minute they have to get an attorney, things kind of changed, which is what leads me to that conclusion.
Yeah.
Just interesting to note that you likely will not win if you contest and you're disinherited, whether by omission or otherwise. What proof do you have of lack of capacity? What proof do you have of undue influence, fraud, or forgery? Good luck. It's very difficult. It usually weighs on the burden of proof and who has to present what. The weapon is the process, though.
Right.
So the fear is the process. If you're going to spend an extra 6 months or a year in court chasing down heirs or fighting frivolous contests, going to needless conferences, or just indulging in motion practice, if you're going to prepare a motion for summary judgment, I mean, you're looking at $5,000, $10,000 right there. I think that's really the
Right.
threat. That's really the issue.
Yep.
The fear of the process. The system is the consequence itself. I think that you will be fully vested. I mean, I could tell you a story about a disinherited heir who never intended to receive, dragged the process out 2 years, lost, still considered it a victory.
Yep.
Wild. If you can't extort a settlement, just
Right.
keep the process going.
Right. It was purely spite at that point.
Oh, yeah.
Purely spite. Yeah. My brother and sister are getting money. I'm like getting like, screw them and the best I can. And,
That's right.
Yeah, I could see that. I could see people feeling that way. And there's if they're being disinherited, there's a lot more baggage that came long before mom or dad's death. So, I'm going to be an obstructionist to you, a polite word. It's part of their personality and that defiance they probably live regarding family matters. And so it doesn't begin at the death necessarily.
Oh, yeah.
So, I'm very fortunate on my parents' estates. There was no battling. I've worked with so many clients in the financial business where everyone got along until the second death, and suddenly they're not getting along anymore. Sometimes over something as simple as jewelry, which is, our family, nobody wanted anything. We said, you take this, no, you take this. It was one of those instead of, I want this, I want this.
That's good.
And
that's refreshing.
it was really easy as far as that goes, I have to say. There was no battling.
That's probably the majority.
I think that's
I'm
the majority.
skewed, though, because all that comes to my table, like if you're seeing me,
Right.
you've got a problem probably.
Well, that's true. So it's fascinating. You've covered so much. Nobody like to go into stories and whatnot, but there was two very simple topics. I have a million more questions, even on disinheriting children. I want to make one other comment.
Sure.
And that is a disclaimer, which is like a child disinheriting himself. And I had one of my clients was a famous actor. I won't mention his name, a television actor. And his sister was a school teacher. And mom and dad were school teachers. They left about $1 million, half to him, half to her. He called us up on the telephone. We sent him a letter saying, fill out the forms. He called us up and says, what do I do not to take this money? That's what he said. What do I not take this money? And
different kind of problem.
A different kind of problem. He said, okay, we'll write up a disclaimer for you. Went to our attorney, wrote up a disclaimer, and all the money went to his sister. He said, I don't need $500,000, but it'll really help her. You don't see that too often. But another comment I want to make is about wills, because you started with wills and probate is, we did a lot of work down in Washington, had private letter rulings and so on, did unique things down in Washington. And we had a Washington law firm, and we're going on a trip, and 4 of the partners were on a private plane that crashed.
Wow.
Yes, and they lost 4 partners in the firm at one time, and one of the partners was in his 30s and had his pension plan, which this goes back to about 1992 or 3 or 4, so quite a while ago. And his sister was his beneficiary on his multi-million-dollar pension plan. And it was a 401k kind of plan. So, meanwhile, he had a wife and 2 children. But he didn't have a wife and 2 children when he put the beneficiaries in place. So this is why you have to do planning. But the sister said, I'll disinherit it. And I'll disclaim it. And we actually flew to Washington to have a face-to-face meeting with the sister, and explain to her that's the right thing to do. And she gave up about $2 million in the 90s, which is a lot of money today. It was a lot more money then. And she wasn't well-heeled, but just knew it was the right thing. And but we felt we had a better chance of succeeding if we met her in person. So my father and I flew down together, met her in person. And she thought about it and said, I have to. But that's not always the case. So do proper planning, number 1. Number 2 is, if you can do trusts and so on, which is a whole long topic, to avoid the probate process. You're not a trust salesman, like you said, which a lot of attorneys are, but they just trust the cash cow. I mean, that was the seminar. So trust can make money. I sold a lot of variable annuities, and people say variable annuities are a rip-off product. They're a great product for the right client. They're a terrible product for the wrong client. The same thing with the trust. It's a great product for the right person. It's an unnecessary product. Never bad, just unnecessary for the wrong person. So work with an attorney, that you feel has your best interest at heart. It's not just trying to work up a bill. Number one. So, and if I was trying to give people a sense of how to, I know what I'd say when you're talking to an attorney. Me, I'm a gut guy. I'd say I'd use my gut. I happen to know attorneys from being in business and so on, but do you have one bit of advice on that?
Yeah, I think anyone who's been to a car dealership could kind of source a attorney the same way. For me, I mean, I try and help out with various different matters, and so my family will come to me and they'll say, "Well, you're an attorney, and you should. Do you know?" It's amazing what I don't know. I don't know. The law is an ocean. I only know this one particular section on my raft, and so they'll ask me for referrals and things like that for employment lawyers and different contract lawyers. I usually start at their website, and I'm not saying it's the best piece of advice, but it's what I do. For my generation, I think your website speaks volumes, and if you have, what I'm going to say is almost going to contradict that, but if you have a very polished website as an attorney, you got to be careful because it's like that.
Slick.
Yeah, it's like that. It's like that enormous menu. You go to a diner and you have an enormous menu,
yeah,
and you're like, oh, look at that. Oh, yeah, they do turkey subs and they do pasta primavera. Oh, and they do General Tso's too. They can't be doing all this right. There's no way.
Spanish omelet. You're always safe at a diner.
That's right. You do a Western omelet, you do a Spanish. You're fine. I usually go cheeseburger deluxe.
There you go.
I try and get those 2 onion rings, but then I always want more.
Yeah.
Now, if you're looking at their website and it has like 400 practice areas, and they do bankruptcy law, and they do cannabis law, and they do they do trust and estates and family law, it's like, you can't be doing all of them to the same level. Be careful.
And I looked at your website before you came here, and we spoke about it before we turned the cameras on, and everything you do is all related. And I like that. I think you had 8 areas of practice, but they were all synergistic. And I like that because I agree with what you're saying.
They're all the same thing stated 8 different ways. So if you say, I'm an estate planner, I'm an estate litigation attorney.
Right.
Well, that's going to encompass administration, meaning if you don't have a will. That's going to encompass probate, if you do have a will.
Right.
That's going to encompass special needs planning and estate tax planning. That all goes into, I can call myself an estate planner and an estate litigator, and that would be done. But I like to list out the subcategories on my website because you never know who's unfamiliar.
Right.
People don't make a distinction between special needs planning, elder planning, and trust and estates planning. And I want to kind of speak to them because I'll get calls and say, do you have an elder law planner there? I know you're a T&E guy. I know you do trust and estates, but do you do elder law? It's like, I mean, they're virtually synonymous. They're not the same. They're different sections in the bar.
Right.
But I would say almost
when it does one, they do the other.
Yeah, they tend to. They tend to, unless they're very, very high end and they're only doing that. In which case, just have your wits about you. Ask somebody that you know. If you do know any kind of attorney, they can usually steer you in the right direction. And like we were talking about before, before we started doing the recording, you never know who's the next guy to do something unethical. It doesn't really present itself that way. So I think word of mouth is likely the best thing to do. And then if you see their website, make sure it's something fairly standard in that they're in their practice area, they're doing what you want, they're within their niche. There's too many people drafting things that they either can't revoke easily or can't revoke, and they're doing it with people who don't do it all the time. So a practitioner who's unfamiliar drafting you an irrevocable trust, it's unbelievable how complicated it gets from there. Because now you come to me afterwards, after this, and I look at this and I'm like, what did they do? I have to revoke the irrevocable trust. I have to almost do, it's not the impossible, but the highly, highly impractical.
Right.
Be aware of who it is that's representing you. People usually say you get the attorney who's most like you. I think that's right. If you want a pit bull guy, you're going to get a pit bull guy. If you want a transactional guy, you're going to get a transactional guy if you're like that. I think the peacemakers go a long way. And the people you can speak to about the bill. Who's the guy you can actually speak to and address what's on the bill? If you can't speak to them about the bill, consider that.
Right. That's a very good point. So we've spoken for most of an hour. It's the question, if there's one takeaway and you want to sort of summarize our conversation, what would it be? If someone's turning this podcast on this last minute, what would they be?
So if you're turning it on right now, I would say the main takeaway.
Go to the beginning.
Yeah, go to the rewind. Yeah. You missed a lot of good content.
Yeah.
But what you want to do is ultimately avoid probate. That's your main takeaway. You should be avoiding probate. Whether you have very little or you have a lot, you should avoid that court proceeding. It's too long. It's too costly. There are very easy ways to do it, and it's always cost efficient to do so.
I'll throw something on. It's also very aggravating. It's very aggravating. Been through it twice.
Yeah.
So, personally.
It's not like it. It's all going to the same spot. So does it go through the court first?
Right. Correct. So, question. So, I thank you very much. So, I have a question. How do people get hold of you?
So you can call us at 631-923-0940.
You want to repeat that?
631-923-0940. Or you could always shoot me an email. I'm Peter Groffmann, and my email is peter@boylesq.com, boylesquire.com.
Oh, so you're on the masthead, but you're not on the email.
I know. It was too hard to change the domain, and, I just gave up at that point. There's too many things moving at once.
That's it. Also, it'll be too long.
Yeah.
All companies leave the key homebuyers, but it's leavethekey.com.
Yeah, plus my name. I mean, I got 2 F's and 2 N's. The double letters really mess you up.
It does. People will not find you. So it was a real pleasure having you. I think this was packed with a lot of information. We kept it down to a niche area, and yet we filled an hour of time.
It really flew.
It really flew. It really did. So thank you very much for coming.
Absolutely. Thanks for having me.
Thanks for listening to this episode of the Unlocking Senior Resources podcast by Leave the Key. If you've enjoyed this episode or found it helpful, don't forget to subscribe, leave a review, and share this podcast. We specialize in working with seniors who are transitioning out of their homes, and we understand what you are going through. So if you are considering selling your home and would like an alternative to the traditional overwhelming process, reach out to see how we can help. When working with us, you can sell your home in its current condition, there is no need to remove unwanted items, and you control when the house is sold, along with so many other advantages. Visit leavethekey.com or call us at 631-388-7771 to learn more about our senior home buying process.